A federal judge just ruled moments ago that a protective order in the election interference case against Donald Trump will only apply to sensitive materials and not all evidence. This just happened during a hearing with Trump's lawyers and special counsel Jack Smith's office on what Trump and his lawyers will be able to say about evidence gathered during the investigation. Trump himself is not at today's hearing. This comes one day after the special counsel asked the judge to begin Trump's election interference trial on January 2nd, less than 2 weeks before the Iowa caucuses. Trump's team will come back with a proposed timetable before another hearing on the 28th of August. The former president reacted on his social media site, calling the January 2nd date, quote, maximum election interference, and that it should happen after the election. With us now to talk more about this, NBC News investigative reporter Tom Winter and Dave Aronberg, state attorney for Palm Beach County, Florida. Gentlemen, thank you for being with us. Tom, what more can you tell us about what happened today?
Sure. So the judge, and we're continuing to get notes from outside the courtroom. It's the media room, and our colleague Daniel Barnes. They're discussing now the idea of posting some of these items of evidence or discovery online, specifically about Trump doing it himself. And the judge apparently said, and I'm going to read a quote, but it's coming from the court, so it may not be perfectly precise. Your client's defense is supposed to happen in this courtroom, not on the internet. And to the extent your client wants to make statements on the internet, they always have to yield to witness security and witness safety. The judge continued saying, I could see the possibility of a lot of problems here. Trump's attorney, Lauro, assured the judge that President Trump will, quote, scrupulously abide by the conditions of his release. And the judge reiterating he's a criminal defendant. He's going to have restrictions like every single other defendant. So it appears at this point that the focus is on, one, not limiting the president's counsel and the former presidents from posting this information online, from talking about this discovery, but a restriction on certain sensitive materials, on what can be shared and not shared. This is an incredibly thorny issue because what's coming up in the courtroom right now. We have a situation where Trump is competing against Mike Pence. I mean, he's far ahead in the polls, but they're competing against each other in a Republican primary. And Mike Pence is definitely, appears from the indictment, going to be a witness against him and might want to address some of the things that Mike Pence has said on the campaign trail comments that we heard last week. So you can imagine this is just a really thorny issue for the judge. What is Trump allowed to say? What can Trump say? When does it cross the line of saying, you know, Mike Pence is wrong, he's a liar, et cetera, if Trump were to make those statements, into when does that become witness intimidation? Chuck Todd raised it last week on the air when this arraignment was going on. What's going to happen on a debate stage? So I think there's really a lot of things for the two sides to hash out. To your point, the judge does seem to rule that it'll just be sensitive materials that'll be under the protective order. But then she then went back and say, all right, well, what is the orbit of people that are covered by that protective order, knowing that Trump's defense team is going to have to hire a number of people to work on this, paralegals, et cetera. She says that she wants a defined list of who will have access to it. And both for the special counsel and for Trump's team, they're going to have to sign on to this so that everybody realizes the rules of the road.